I also want to maybe point out the elephant in the room, that there's some reason that Ms. Silth is currently in a Ferguson gown and handcuffed behind her back in this hearing, which this is atypical. This is not typical. I don't know what's going on. I can only surmise unless someone wants to tell us what's going on. Meeting with your staff member, you saw another program participant and shouted at him. The other resident continued walking. You ran out of your apartment with a metal bat. You chased the other resident and hit him in the arm with the bat. Police were contacted and you were issued a citation for disturbing the peace, which carried a $109 fine. On 4/23/24, you came to staff and reported that you had broken a window in the apartment intentionally by throwing a chair at it. Your behavior meets the threshold of 53A-117 criminal mischief and third. On 4/25/24, you entered the staff office to use the phone. At 7:45 a.m., you became agitated and bent the staff office phone, breaking it. At 8 a.m., you ripped the door off your bathroom vanity and threw it from your apartment door into the community circle.
And the list goes on and on and on, and we're about to hear the full extent of it. Now, we are watching a parole revocation hearing out of the state of Connecticut, and the one thing that this inmate has going for them is, I think, the best public defender in the state of Connecticut. I mean, if you're a public defender, you don't want to see your client roll up in that kind of predicament. This is something we have never seen before.
Good morning, Ms. Sills. How are you?
Good morning.
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Justice Sills 399-254. Today is Friday, August 30th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
Justice Monier Sill, 399-254.
This is a public hearing. Present this morning is P.O. Goodman, as well as your attorney.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit. Hello, Justice.
Hello, Rob.
Good morning, Justice. Kimberly Goodman for Parole and Community Services Mental Health Unit.
Thank you.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. P.O. Goodman, you're not muted.
Oh, my apologies. Sorry.
If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. P.O. Goodman, in this, I'm going to actually ask that your attorney can you raise your hand for her? I mean,
Can you, are your both of your hands down, Miss? Okay, so I can't do it,
You can do it,
for her,
right,
but you can at least say that you. Okay.
okay, so I'm going to just place you under oath. Okay, so I was going to make this say yes at the end as long as you're in agreement.
Okay.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
Thank you.
Can I just ask, Justice, are you okay? You look like you're in a lot of pain.
Oh, I'm handcuffed by the back from this chair. I could move up a little bit if people are coming. I'm not in a lot of pain. I just express the face.
Okay. I just wanted to make sure you're all right.
We now review the charges of the state your officer is bringing against you and the information underlying each charge. Peel Goodman?
Yes, ma'am. Charge number 1, release direction. Under program participation, you were placed in a mental health Connecticut Parkview supportive housing program. Upon admission, you were issued a handbook outlining the program's rules and regulations. You signed acknowledgement forms agreeing to abide by said rules and regulations. As a result of your willful violation of these rules and ongoing, escalating, and dangerous behavior, you were unsuccessfully discharged from the Mental Health Connecticut Parkview program, which was funded by Demas on April 25th, 2024. Charge 2, obey all laws. Since your admission, obedience to the law, since your admission to Parkview Supportive Housing Program, you have caused significant damage to your assigned apartment. Damage includes numerous holes in the walls, drawings and writing on the walls, unsanitary conditions, and possessing contraband. Your behavior meets the threshold for 53A-11-6 criminal mischief in the second degree. On 4/20/24, you entered the staff office at Parkview Housing Program for your medication. You proceeded to enter the back office and take program supplies. When redirected to put the items back, you punched the wall, then proceeded to smash a flower pot on your way out of the office. Your behavior meets the threshold for 53A-11-7 criminal mischief in the third. On 4/22/24, while meeting with your staff member, you saw another program participant and shouted at him. The other resident continued walking. You ran out of your apartment with a metal bat. You chased the other resident and hit him in the arm with the bat. Police were contacted and you were issued a citation for disturbing the peace, which carried a $109 fine. On 4/23/24, you came to staff and reported that you had broken a window in the apartment intentionally by throwing a chair at it. Your behavior meets the threshold of 53A-117 criminal mischief and third. On 4/25/24, you entered the staff office to use the phone. At 7:45 a.m., you became agitated and bent the staff office phone, breaking it. At 8 a.m., you ripped the door off your bathroom vanity and threw it from your apartment door into the community circle. At 9:45, you were observed by staff kicking in your apartment door. You kicked it so hard you cracked the frame, and the door was no longer able to close. At 10:45 a.m., you flipped the community circle picnic table when leaving the property, causing it to be damaged. At 2:45 p.m., you were observed throwing a bag into the community circle. It was filled with glass and garbage. You were observed spreading the glass and garbage in the parking lot. These behaviors meet the threshold of 53A-117 criminal mischief in the third. D, drugs. On 3/18/24, you tested positive for cocaine on an oral swab. The swab was sent to Premier Biotech Labs for confirmation, and the positive result was confirmed. As a result, you are in violation of release direction, obey all laws, drugs.
The state has filed the following exhibits, starting with Exhibit A.
I'm sorry, one moment, please. Exhibit A, I don't actually know. Oh, yep. Exhibit A, signed parole conditions. Is Exhibit B, remand to actual custody order. Exhibit C, notice of parole violation, parolee rights. Exhibit D, parole violation report. Exhibit E, Demas critical incident submission form 4/22/24. Exhibit F, Demas critical incident submission form 4/25/24. Exhibit G, mental health Connecticut discharge letter, behaviors of concern list. Exhibit H, mental health Connecticut residential services handbook and signed acknowledgements. Exhibit I, photos of property damage on 4/25/24. Exhibit J, photos of apartment damage and disarray since admission. Exhibit K, positive drug screen and misconduct. Exhibit L, MHC video footage 4/22 incident located on the X drive. Exhibit M, criminal mischief second and third descriptions, and Exhibit N, previous revocation summaries and hearing dispositions.
In June 2024, the state filed an addendum to Exhibit D, which stated on June 11th, 2024, Ms. Silk was served a warrant and arraigned on charges of breach of peace second and criminal mischief first for her behaviors that occurred on April 25th, 2024. At such time, probable cause was established. The state submitted additional evidence that was not available at the time of the preliminary summary. At the time of the preliminary summary was completed. Addendum evidence consists of Exhibit A, authorized arrest warrant, Exhibit B, continuance of minimus, and Exhibit C, judicial branch pending case detail. In August 2024, the state filed an additional addendum to Exhibit D, which states on August 6, 2024, Ms. Silk was found guilty of breach of peace second and sentenced to 90 days jail, and the charge of criminal mischief first was nollied. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have.
And defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and Exhibit 2, letter of support. Today, we have no witnesses, and at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. Feel Goodman?
I, with all due respect, I think the charges speak for themselves. I would much rather like to save my commentary for history and background.
At this time, the state will, or the defense, it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Yes, I have no comment regarding the preponderance charge for charge 3, the preponderance standard. As to charge 1, the allegations are conclusory, just as rules violations, discharge from housing for rule violations, essentially. I just think that that's not specific enough. So I don't believe it meets the preponderance standard. As to charge 2, the only charge that she pled guilty to was the breach of peace, and the second degree received 90 days, and all the other charges were unsubstantiated. No pleas resulted. Thank you.
Charge 1, program participation. I make a finding based on state's exhibits A, D, E, F, G, H, and L. On charge 2, obedience to the law, a no finding was made on parts 1 and 3 when the preliminary summary was completed on May 14th, 2024. Therefore, these charges will not be considered at today's hearing. On May 14th, 2024, a no finding was made on part 5 when the preliminary summary was completed. However, the state submitted additional evidence that was not available at the time the preliminary summary was completed. Given the additional evidence, I make a finding on parts 2, 4, and 5 based on Ms. Silk's conviction, as well as state's exhibits A, D, and F, as well as addendum exhibits A through C. On charge 3, drugs, I make a finding based on state's exhibits A, D, and K. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. First, we're going to start with Theo Goodman. Would you like to make a statement regarding Ms. Silk's background and history at this time?
I would. Thank you so much. We've been working with Ms. Silk since 2017. We have attempted to place her in several community program options, and those have been unsuccessful. The last 2 options were the Parkview program, which is funded and paid for by Demas. And in order to get Ms. Silk into that program, on both occasions, we had to take her case up to the Department of Mental Health and Addiction Services Commissioner's office in order to find appropriate funding and housing to keep the community safe and to keep justice safe as well. Because of her ongoing and continued behavior, she has made it almost next to impossible to place her in any DOC funded programming, which is why we have to have specialized programming. And this specialized programming takes quite a while to get. This is her 5th violation. She has received sanctions anywhere between 6 and 9 months, and we have utilized in the field that time to secure appropriate placements for her. However, those placements don't really seem to be to Miss Silk's liking, and subsequently she sabotages those placements by acting out in the ways that are described in this violation report and in the ways that are described in the previous revocation summaries. We've attempted to place her in a halfway house where she committed an arson by burning things in the trash can. she was involved in another halfway house in a sexual assault, which was a Priya incident. She's been arrested multiple times for indecent exposure, for interfering with an officer, assaulting an officer, and grabbing his taser, attempting to grab his taser, excuse me. And her behaviors continue to escalate. You saw in the video that she actually went after someone with a baseball bat, when they weren't responding in the way she wanted them to respond. She I see that I did receive her report for her parole accomplishments, and it said that she had gone to Stonington through 3 days. Well, Stonington is not a 3-day program, and in 3 days you're not going to address an addiction to cocaine. And as a matter of fact, I quoted in my report that the only thing she got out of that program was a smoking habit. So she didn't successfully complete that program. So it's essentially a bit misleading, that report. It indicates that she's amenable to any treatment, amenable to any placements, but it hasn't mattered where we've put her. She doesn't actively engage in treatment. At times, she's refused to take medications. We do everything in our power to actually help her move on, and get to where she wants to go. But she does things intentionally, as she admitted to myself and Officer Montoya, to get out of situations that she doesn't want to be in. I get that it's not easy to be on supervision and that you don't want to be supervised, but in order to keep the community safe and to keep justice safe, there's certain steps that we have to take, and we can't keep somebody out in the community who would cause that kind of damage and destruction to their own apartment. And quite frankly, an apartment that she wasn't paying for. So if you were to revoke and reparole her, we would need quite a bit of time in order to secure a more appropriate setting, because halfway house placements haven't worked. Treatment programs haven't worked. She was at Blue Hills. That didn't go well when she wasn't getting her way. She threatened not to eat. There's just a plethora of sorry, I got tongue tied for a second. It's just there's a lot of moving parts that we have to address in order to keep the community safe from her, and to keep her safe from herself.
Counsel, do you wish to make a statement regarding Ms. Silph's background and history at this time?
Yes, I do. My client is 38 years of age. She's divorced. She reportedly attended Middlesex Community College online studying psychology, and she's about 2 courses shy of earning her associate's degree. For her disability, she receives Social Security. She has a history of psychiatric hospitalizations. While placed, she was sent many visits to the hospital for ideation, and she was released without care. She was placed in the past in female housing and mixed housing, and she states that that's more successful for her. She, unfortunately, when she's placed at DOC, she has to be segregated and is placed with males. Many males approach her, and that makes it difficult for her. She's been incarcerated now for over 4 months for the discharge for housing rule violation, damaging property for which she served 90 days, and 1 positive cocaine urine within a supervisory period of 10 months. She received no graduated interventions and sanctions, and they are recommending that her parole be revoked and reviewed annually. I don't believe that's appropriate. I think it's draconian. She is disabled. She does carry. We are only talking about a period on the 20th of April, 22nd of April, 23rd of April, 25th of April. Those are the dates, and 1 positive urine from March 18th. She has been with parole on this period of supervision since June 23rd of 2023. Like I said, 10 months, just those isolated incidents. She has a history, as I said, hospitalizations. She was on the job waiting list at Osborne Correctional. She wishes to return to Middlesex Community College to study psychology. She's also interested in learning Spanish. She cannot work due to her disability. Justice, where do you wish, or does it not matter? You just want an appropriate placement. Does it matter where you're placed, or you're just seeking an appropriate placement?
I can't speak unto what I think would be appropriate because like nothing's worked so far.
Okay.
I feel like if I was
Is there any particular area, or does that not matter?
for area, I prefer New Haven, Bridgeport, or Danbury.
But you do understand that it may be difficult to place you.
Why?
Okay, so you disagree with that.
No,
Okay.
it's not that I disagree. I just understand why.
Well,
I don't.
well, there's been representations made that it's difficult to place you. Are those true or not?
Those are true. Although DOC has never tried to place me as a female. I realize that their current rules don't allow them to.
Okay.
But I feel like I'm not as bad of a mental health issue as like it may have to be, and I feel like I'm much more. I don't know. I'm here right now in this DOC setting, and it's almost impossible for them to place me because men approach me or men call me faggot, and it's not like a livable scenario. They put me in mental health like for treatment setting, and I'm with people that are depraved, people that aren't lucid ever, people that aren't cogent ever. I just feel like I've been deprived of being like in the real world almost, and as like an LGBTQ person in the real world, I have a community, whereas like I've been deprived of that, and I don't.
You do realize that when you're placed and you're on parole, there are restrictions, correct?
I do
And you
realize
have to
that,
abide, and you have to abide by those rules, correct?
yes,
And you understand that where you're placed, you can't damage property, correct?
yes, I do. I wasn't really in control myself at the time. That particular placement, it started off very good. It had lots of staff I could relate to and got along with, and lots of they pride themselves in being a community setting, and it started off good. And then at some point, towards the second time I was released, I'd say like 85% of the people smoke crack. Now I've been to psychiatric diagnosis. I've been psychiatrically labeled for well over 20 years.
Right.
Part of that is having boundary issues.
I understand that.
It's all the boundary issues in place.
Justice, Justice, I'm trying to cut to the chase. Do you understand, having been incarcerated for 4 months now, that breaking things is not a solution?
Yes.
We also have a letter of support from Ashley, one of Justice's friends, and that was submitted as an exhibit. Have you had a chance to review that?
Yes.
Hearing examiner Saunders?
I haven't had a chance to review that. I didn't receive that. The only thing I received was a review report from the social worker.
Okay.
I just want to put that on the record.
Okay, thank you.
Do you want a moment to review it?
I don't have it.
I guess I can send
I
it.
don't necessarily know if I have to send a copy of the exhibits to there's no duty to send a copy of the exhibits to the parole officer. I don't believe we sent you a copy of our list of accomplishments, did we?
Yes, I did receive that. And
Yeah.
I addressed that because of one of the accomplishments that was listed was a participation in Stonington for 3 days.
Okay.
And I said earlier that was misleading.
Okay. So I think generally what our argument is that although my client has been difficult to place, and although my client has contributed, and I think she would agree that she has contributed to that difficulty to place her because of her conduct here and her prior conduct, she's received no graduated interventions and sanctions. And these are isolated incidents over a course of 10 months of parole for this period. She's been incarcerated for 4 months. I don't believe it's in the interest of justice to essentially sentence an individual who received a breach of peace in 90 days, 1 cocaine urine, and was discharged for rules violations to jail indefinitely. And I also don't believe that not having an appropriate place to place her, part of which is due to her orientation, is appropriate. She has admitted her conduct. Even if we admit all of the conduct, if everything in the allegations is true, I don't believe a full revocation of her parole is warranted in this case. I don't think these violations are so serious enough to warrant incarceration of that period of time. Thank you for your time and consideration.
Phil Goodman, would you like to state anything else regarding Ms. Sue's background and history at
Yeah,
this time?
just really quickly, I think, recent past behavior can be indicative of future behavior, and all the violations that she's had, all 5 of them, you have to take them in their totality. I understand this is just one violation, but there are 4 more. This recommendation, while I think, the attorney used the word draconian may have been making that recommendation at the first violation, not the 5th. I also want to maybe point out the elephant in the room, that there's some reason that Ms. Silth is currently in a Ferguson gown and handcuffed behind her back in this hearing, which this is atypical. This is not typical. I don't know what's going on. I can only surmise unless someone wants to tell us what's going on. I just think that looking at the totality, her behaviors are progressive, they're ongoing, they're continuing, and regardless of the amount of time she's received as a sanction, whether it's 6 months or 9 months or a year, or she's previously been convicted of other charges and in other violations, this behavior continues to happen. And it's appropriate to take responsibility in the moment when you're in this hearing, but it's inappropriate when you're in the community committing those crimes. And let's face it, that the criminal mischief charge may have been nollied, but she caused $2,200 worth of damage, all because she didn't want to be there. And she flat out told us in the violation report, I wrote it, it was a quote. I said, well, I guess you got what you wanted, because she didn't want to be in Torrington. And she smiled and she said, yep, I did.
Can I respond?
May I speak?
Well, one moment.
Please.
I just want to respond briefly, and then certainly you can speak. What she appears to be in, as far as her garb, or whether or not she's in some sort of a gown, or that's not evidence in this case. So there's no need to address that, one. Second off, even if we assume all of the charges, she's charged with damaging property and a breach of peace. Okay, the breach of peace is a misdemeanor for which she received 90 days. I don't think we should jump where her prior sanctions have been 6 months and 9 months. She received 90 days here. Even if she did damage property, we're talking at about a misdemeanor level of value for damage to property at $2,200 here. So we should not be treating this or even thinking of completely revoking her parole. Thank you.
I just want to put on the record, she was charged with a felony. It was nollied, but just because it was nollied doesn't mean the behavior didn't happen.
Even if it happened.
Thank you.
Even if it happened. $2,200 of damage does not require or call for a revocation of her probation, of her parole. Excuse me. Thank you. Miss, do you wish to be heard now?
I wanted to speak to the previous revocations. The first time I was put into Renaissance East, it was very clear that I was going to be very different from everyone there. One night I was approached 4 different times for sex in my room. The staff allowed that to happen, but then what happened was I burned white sage incense and a $1 bill in a trash can, or not a trash can, a coffee cup, and lots of other clients there were burning incense. But because they knew that I was having sex and not really hiding it, they they revoked me. The second time, there were three not openly, but three gay people in the half house, and they were, they were my friends. And I jokingly went to act like I was going to fillet one of them, but I was well over 6, maybe even 12 inches away from the entire time. And a third party happened to see it, reported it, and I was recorded. I requested him as a witness so that he could speak to the fact that he didn't care, and he was my friend 10 seconds later, for 10 seconds during the entire incident, and that wasn't heard. I feel like if I was in the community, not a DEMA setting or DOC, I feel like if I was in a DOC setting and a female setting, I would do just fine. I wouldn't be pressured for sex. I wouldn't be in these ridiculous circumstances where I'm pressed to have sex. And I feel like if I wasn't treated like an invalid, or like in Parkview, I felt like I was almost forced to smoke crack. I have very little boundary issues, and people would come to my apartment and say, buy crack, buy crack, buy crack, buy crack. And I didn't want to go down that road where I felt like I had 7 months left to live and be healthy. I'm a healthy individual. I just have boundary issues, and I wasn't allowed to have another person in the apartment to ward off these people for me. I was forced to be part of the community I didn't want to be part of. I realize I'm responsible for the damage, and that's not the way to go about things. But I was stressed, and I don't know. I feel like it come 2.5 years, if I am, God forbid, sentenced to my entire parole hearing, I'll do just fine in the community when I'm actually in the community. But I haven't seen anything even close to it in a really long time.
Thank you.
Thank you.
Field Goodman, anything further?
Just to say that while she was in the community, the last 2 times she's had her own apartment.
And P.O. Goodman, I do want to say, I look back at the email chain. You are on the email for the updated list of exhibits for the letter of support. It was sent yesterday around 2:00.
Well, okay, let me just double check. Was it with the other exhibit?
No, it was sent separately. We sent a second batch out. Because what happens is my social worker will send in her exhibit. I will review it, will be sent. And then later in the day, I remembered that I had the letter from the friend, and I gave it to our secretarial staff to amend our exhibit. So there's exhibit 1 and exhibit 2 were sent, perhaps after the 2:00 hour.
I did get the first one around 1:22, and this just said I sent an updated list. So maybe I missed.
You want to review it now? It's about a paragraph.
Yeah, I'm opening it
Okay.
now.
Okay.
Thank you. Hold on.
So anything further before?
Nothing further from me unless there's comments made as a result of the letter. I've just reserved the right to respond.
Oh yeah, here it is. I see it now. Okay, I have read the letter. The only question I would have is I don't understand what is being referred to regarding being forced to take medication. She was on no forced medications.
No, I understand. I don't believe she was on forced medications either.
So that would be my only.
We're not, we don't support that position.
And I also want to say that the Parkview program isn't Demas housing. It's run by the mental health. Sorry, I don't know the exact terminology. 1 second for it.
Mental CT.
Yes, yep. It's run by them and it's funded by Demas, but it's not Demas housing. It's independent living. And she was more than welcome to have guests and company. They just weren't allowed to sleep there.
No, I wasn't allowed to. I mean,
I think we're
Yeah, I
going
agree.
off target now.
I agree. Yes.
Okay,
thank
I
you.
don't think that necessarily requires a response. I don't believe that, unless I'm wrong, hearing examiner
Regarding the
Saunders.
charges.
Yeah. Okay,
Yep,
thank you.
Thank you.
Okay, nothing further?
Nothing from the defense.
I recommend revoke and reparole on February 25th, 2025, which is an approximate 10-month sanction. This is Ms. Thill's 5th parole violation. While on supervision, she received 1 misconduct for testing positive for cocaine and accrued an additional conviction and was unsuccessfully discharged from her programming due to her behaviors. I recommend the following conditions: no consumption of alcohol, no contact with victims LM and JM, halfway house placement, and mental health treatment. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on September 12th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. This concludes the revocation hearing.
Okay, so Justice, give me a call on September 13th, and I will let you know what the board decided. The recommendation is a 10-month sanction, which is 1 month longer than your prior longest sanction. Okay?
I have the main part of my disability is temporal. Like I'm not gonna remember like the date of this like 3 seconds later. Like,
Okay.
like 3 seconds. Is there any way you can mail me that date? Or
They will be mailing you a copy of the results once the board meets on the 12th.
thank you.
This is not a
Officer
final decision.
Officer Saunders, you said February 25th?
February 12th. I'm
Oh,
sorry,
12th.
I'm sorry. So February 25th, 2025. Yes. And
Thank
then
you.
September 12th is the board review.
Understood. Thank you so much.
Thank you.
Thank you, Attorney Famigletti.
You're welcome.
Have a
Just
great
give me
day.
a
Bye,
call if you have-
Justice.
I think.
Justice, give me a call if you have any questions.
Okay,
Justice, be well, okay?
I'm trying.
All right. We'll see you soon.
Mhm.
Bye-bye.
Hey, they're done.
Okay, so let's unpack this, and I'll do the best that I can because there's almost no information on this inmate, and we believe that it's because the inmate has an alias, another name that for whatever reason the DOC is not listing. Typically, they list all of the aliases, but in this case, it's not there. Now, it was recommended as a 10-month sanction, which would be, I think, another from this date, like 5 months to serve. So, hey, maybe it's something. At least they didn't say, sure, just go out there and have fun. Let's see if history won't repeat itself. Now, the board will review it. We do have access to those reviews. If there's a change in the sanction, I'll pin it in the comment section. Very rare that there will be any change, but if there is, just check the comment section. It will be pinned. Otherwise, this is just insane. I mean, let's remember the big elephant in the room that you roll up cuffed, as what the attorney calls just a gown. Who cares what my client's in? A gown. It's a nice gown. And they don't ask about it. They don't ask about it. There was like a hot mic at the beginning, I think, talking about write-ups or something, but I couldn't make it out. And why are you cuffed? How are you even having a revocation hearing? Like, it doesn't even make sense. What did you think the result's going to be? I mean, clearly this person should not be out and about. Clearly. And do you think something's going to change? Remember, they've been locked up for like 5 months already at this point, give or take. I don't know. And they still show up in cuffs? It's it's interesting. The attorney's trying to make these points. Well, it's my client doesn't want to be in DOC with males, wants to be with females, and they don't. And there are halfway houses that are co-ed, and then as the Richard research, so we know that exists. And then, but on top of it, the parole officer makes a really good point and says, this inmate has had an apartment, a solo furnished apartment given, and twice violated having their own apartment. It's like what I'm seeing here is the system that is bending over backwards in every which way to try to give to this person to succeed. And yet this person violates over and over and over and over and over. And not just in any ways. We're talking about chasing people with bats and trying to take tasers from police and lighting fires in your apartment and throwing. I mean, you're the problem. Look at yourself in the mirror and say, stop blaming other people. And the worst is having others that are like just trying to make excuses. I get the attorney has to do his job, and and if there's anyone out of Connecticut in this whole scenario that I want to have a beer with, it's that attorney. I have a lot of respect for his creativity, and he just, how can my client only did 2 little things wrong? Oh, it's just theft. Come on, what's the big deal? You're gonna lock them up for 10 months? It wasn't even a felony in the PO. It's interesting. In Connecticut, the parole officers, they're not just like parole officers that have the power to arrest and to carry a weapon but they also have to be able to debate at the level of an attorney in an adversarial proceeding. That's like, we have seen this a lot, and it's impressive. And I don't think they get paid it. I mean, it's hey, if you want a stimulating job that's always changing and challenging, be a PO officer in Connecticut. Also, you might want to be a masochist. Is that the right word? If you take that role, but and then still wanting more. No. See, it's still the problem. The problem lies in the system. See, DOC's still not housing me with women. If they would just house me with women, everything would be okay. It's like, what? You literally got your own apartment. I mean, think about that. Imagine getting arrested, spending time in prison, and because of whatever reason, the DOC decides, you know what, we are going to take taxpayer money. We're going to skip, there are plenty of people that can use Section 8, the mothers with children that are having hard time, that are working hard, that are doing everything right, but they simply can't afford housing because who can? And no, you're going to skip the line. They're going to wait. We're going to give it to this inmate because they don't want to be housed like everyone else. Think about that. Just think about that. How many more people that would not have lit their apartment on fire, that would have appreciated it and treasured it and maybe have stayed in it till the end of time, like it was their own home? No. It's like when the loonies run the asylum, this is the result. And I don't know what the answer is, frankly. I mean, do you keep someone locked up forever? Like, what is the answer? I don't know. But the idea that you can even only have that you show up in cuffs, something we have never seen at a revocation hearing. Actually, we saw a gang member show up in cuffs, but the cuffs were not behind his back, and he wasn't in this gown. So we did see that once, but that was because they assigned him a thing as a gang member, so he was classified different type of thing, not because he was acting out. I think it was just a classification thing. That was an interesting one. He had a great attorney. Man, the attorney actually owned the parole officer. But you know, how can you expect a parole officer? He had a paid attorney. It wasn't a public defender. But the yeah, there's nothing. We don't have anything. There's no records really. There's no crimes on in the jacket, and that's probably because of the alias name or a name change or something. I don't really know. Well, all we have here is a 2015 breach of peace, a 2019 interference with an officer, which I think was a taser thing, the 611 arrest, 6/11/2024, which is a breach of peace, second degree. There's also it's just like 425/24, something else. But there you go. There you have it. You can't make it up. I know that I you know, vented a little bit. I don't know what the answer is, but clearly this isn't working, and I don't know what could, but with that, I'll let you go.
I also want to maybe point out the elephant in the room, that there's some reason that Miss Sylth is currently in a Ferguson gown and handcuffed behind her back in this hearing, which this is atypical. This is not typical. I don't know what's going on. I can only surmise unless someone wants to tell us what's going on.